Nowadays, in the Australian legal profession, the role of in-house lawyer has been growing, bringing with it new challenges and new ethical issues. Within the regulatory framework of a lawyer admitted to practice, the duties of in-house counsel are the same as that of other legal practitioners.
Anna is an in-house lawyer for PetLove. PetLove develops a shampoo for dogs. During the preparation of the launch, the research department advised her that the shampoo contains an ingredient that can be toxic, but the manager decided to ignore the problem and withhold the risk from the CEO and the board. Anna advised the manager that there would be a legal risk if the company insists on introducing the shampoo. The manager told Anna that they can claim privilege for most of the documents. This made her suspect that PetLove used to abuse the privilege claim. Anna tried to convince the manager to report this to the board, but he began to grow impatient. He told her that her performance review would be done by him.
Ethical problems faced by in-house lawyers are different from those faced by lawyers working in an external law firm. The key difference is that lawyers working in an external law firm usually have different clients and employers. By contrast, the client and the employer for an in-house lawyer could be the same person or company. That means for in-house lawyers, they are harder to maintain independence or deal with conflicting interests. Those difficulties are also recognized by European courts, as we cited below. We are going to use Queenstown model to resolve ethical problems in this scenario. There are two questions in this scenario, and I will focus on the first one. The first question is that Anna noticed the potential legal risks which could be harmful to the business interest of the company, and she warned the manager. However, the manager asked Anna to ignore the problem and insisted to introduce the product. What should Anna do when she faced with the manager's instructions that conflict with the business interest, ethical or legal compliant? According to the requirement of the Queenstown model, we consider the three apparent resolutions for this problem. The first one is that the manager asks Anna to ignore the risks. The manager will also evaluate Anna's performance at the end of the year. So Anna should follow the instructions of the manager to protect her personal interest. The second resolution is that Anna should raise this legal risk with the CEO or board even the manager objects. She should act as the gatekeeper of the company to ensure the legal compliance. And the last resolution is that Anna should not only raise these legal risks, but also persuade the company to give up the new shampoo. Anna, the PetLove company, and the consumers have different interests in this scenario. For Anna's interest, the manager could decide Anna's bonus and evaluate Anna's performance. So Anna's interest at here is her financial interest and potential opportunities of promotion. For the company's interest, the company needs to know and find a way to avoid legal risks which could make the company suffer from financial loss and reputation loss. And the last one, the consumer's interest is the quality of the products. No one wants to pay a lot of money to get products which are low quality and harmful to their beloved pets. In order to resolve the ethical problems in this scenario, we consider the three different duties mentioned by legislation or case law. The first one is about the independence, which means lawyers should always avoid any compromise to professional independence. He or she should have his or her own judgment about the case. The second one is about communication and act as a gatekeeper. Lawyers should always communicate and voice their clients, and also for in-house counsel. In case ASIC and McDonald, judges say that an in-house counsel's primary responsibility is to protect the company against legal risk. And the last duty is that the lawyer should always consider the client's interest. There are also some broader ethical considerations in this scenario. The first one is the life of pets. Pets are our friends. They accompany people and bring happiness to people. Their lives are also valuable. As a person, we should protect the pets rather than harm them because of financial interest. The second consideration is the protection to community. As I mentioned, pets are humans' friends. There are always strong emotional connections between a pet and its host. In other words, Any harm to the pet will lead to mental harm to its host. In Australia, many families have pets, so Anna should consider the protection to those families. Anna could always get some help from other persons. For example, he could consult with her colleague about this ethical problem, and maybe he could also connect with the New South Wales Law Society and find some help about the ethical problems. Different resolutions will have different consequences. If Anna decides to follow the manager's instruction, Anna will not suffer from any personal loss, but the company would have to face potential legal risks. If Anna decides to raise the legal risk with CEO abroad, she might be punished by the manager because she didn't follow the instruction of the manager. However, the company will realize the risk and will decide how to deal with that risk. If Anna also decides to persuade the company to give up that products, and maybe the company could be persuaded and give up that product, both the company and consumers would be protected. Anna should make a final decision. She should not follow the instruction of the manager. She should act independently, and also follow the instruction of the manager would harm the interests of the company, which are not allowed by both legislation and case law. To raise the legal risk to CEO abroad is a good choice. In this kind of situation, Anna satisfied the duty of an in-house counsel, which asks her to protect the company against the legal risk. But we think there is a better choice. We think the better choice is to persuade the company to give up that products. We think that a better lawyer should not only consider the interest, but he should also consider some moral problems, and also she should consider the protection to the entire community. Anna should also summarize the diary notes which reflect the ethical problem that she faced and the way she resolved that ethical problem. That is all about the issue 1, and my teammates will introduce issue 2 to you.
The second issue is how to balance the conflicts between lawyers' legal and ethical obligations in relation to privilege and the interests of the client. The underlying concern with extending privilege to in-house lawyers was explained in AXO Australia Resources. Documents prepared for the information of their superiors would also be provided to in-house lawyers for the purpose of obtaining legal advice or assistance. It was regarded as unacceptable and contrary to the interests of justice that such documents should be privileged merely because one of their intent destinations was the death of a lawyer. Therefore, the challenge is how to maintain ethical conduct, keep on the correct side of the line between legal and non-legal work, and act in the best interests of the client. There are different options in terms of different approaches of lawyering. For adversarial advocacy, the lawyer advances Pet Love's interests with maximum zeal permitted by law. She will ensure more communications are protected by privilege by fulfilling the test of privilege, and she will claim privilege as practical as possible. Responsible lawyers think they have an overarching duty to the administration of justice and service to the public interest. She will only claim privilege when the test of privilege is satisfied, the intention of client is ethical, and the underlying purpose of communication is sufficient to justify privilege. Moral activism places the lawyer in the role of agent for justice. She cares about public interest. If the use of privilege disadvantages the ability of parties to litigation being able to fully test the veracity of the client's claim, she will persuade clients not to abuse the privilege claim. An ethic of care sees the lawyer's responsibility as being preserving relationships and avoiding harm. Therefore, if the use of privilege will harm the public or the customers, she will not do it. Pet Love's interest is that it needs to keep more communication confidential as possible so as to disadvantage other parties' ability to the litigation. Lawyers' own interests are that she wants to secure her jobs, provide satisfactory service, maintain a satisfactory professional and ethical conduct, and not to contravene the laws. The public interest is for the company to disclose information where the court requires the company to do so. Consulting a source of authority may assist Anna to make decisions as they demonstrate what the laws require lawyers to do. The authorities for this issue include the law of legal professional privilege, the duty to educating the client, the duty to administration of justice, the rule of independence, and the duty to act in the client's interests. For broader ethical considerations, the abuse of privilege claim may render the customers vulnerable to the claims for damages, and the public will continue to be harmed by Pet Love's products. As a legal practitioner, she also needs to consider about her personal values, including integrity and professionalism. The Solicitor Conduct Rule 9.2.3 stipulates that lawyers may disclose clients' confidential information in a confidential setting for the sole purpose of obtaining advice in connection with the lawyer's legal or ethical obligations. She may discuss the issue with a more senior and experienced practitioner, colleague, or an ethics guidance officer in order to gain different and objective perspectives to help her with the decision-making process. If Anna embraces the adversarial advocacy approach, she may be involved in dishonest and misleading conduct, and she may breach the duty to the court and the administration of justice. For the other three approaches, the client might not be satisfied with her service.
Now we will discuss some strategies that could help to prevent the ethics issues from recurring. At the company level, it could be possible for boards and CEOs to discuss or incorporate policies. Some of these policies could be the following. Firstly, staff legal training to create awareness of the ethical dilemmas and provide tools for employees to consider and propose solutions. Secondly, provide a more senior counsel as an advisor to in-house counsel. Wise decisions come with experience, and this will help to provide fearless advice. Thirdly, incentivize a culture of honesty. This will help to allow in-house counsels to engage in ethical considerations that create more sensitivity to ethics issues and generate more accountability. Finally, transparent policy, promoting ethical behavior as an important part of the company practice. At the staff level, the following strategies could be effective. Firstly, internal ethical audits could guarantee there is compliance with the principles and rules. Secondly, more members in the legal department could also offer more support if these issues arise. Finally, salary incentives could be implemented to reinforce good ethical behavior. At the professional level, will be important to promote giving voice to individual values that can help to cultivate the independence of counsel. Secondly, to incentivize awareness of the interests of individuals and stakeholders. Thirdly, to avoid a standard conception approach. And finally, to consider and establish core values. Now we will discuss some reforms that could allow to improve this area. Firstly, to allow in-house counsel to represent more than one client might help to alleviate financial pressure on in-house counsel to act unethically. Secondly, to reinforce the concept of the lawyer as an officer of the court. This is just a reminder to in-house counsels that the paramount duty is to the administration of justice. Thirdly, to introduce sanctions that deter the breach of independence. Fourthly, the Australian Law Reform Commission recommended introducing a statute of general application to clarify the application of privilege. The Australian Law Reform Commission also recommended that the Attorney General work with the state and territory attorneys generals to achieve the harmonization of laws and processes relating to client privilege. This will help to unify legislation and create a better understanding of the practice. Finally, more accountability for the CEO and the boards will be useful to create more awareness in the corporate level. So thank you now for your time, and we wish you a great day.